for judgment.
Writ petition is partially allowed and the compensation entitled to the petitioner is calculated at 28 lakhs and a few thousand, which this court considers as a just and reasonable compensation. Yes.
Obliged.
Petition, item 2.
May I seek your Lordship indulgence in mentioning part 2, item 2. My Lord, last Friday we were instructed to obtain instructions from a client. So we both agreed, both parties agreed to be referred
Okay,
to local.
for local talents and try and settle,
Yes, my Lord.
okay, because you all are siblings and nephews and nieces, isn't it?
Yes, my Lord.
Closely related. Yes. Mr. Lalbek Nunganampe, learned counsel for the appellant, is present along with Mr.
Samuel Lompuya.
Samuel Lompuya, appearing on behalf of his senior Mr.
Zoram Sana.
Zoram Chana, learned counsel for the private respondent parties. It is submitted by the learned counsels that both the parties are willing to make an attempt to come to an amicable settlement at Lok Adalat. In view of the above submissions, matter is to be referred for settlement at the at Lok Adalat through the Legal Services Committee, a High Court Legal Services Committee, registry to do the needful. Yes.
Obliged, my Lord.
My Lord, with regard to item number 12 of part 2, if this matter may be taken up tomorrow, my Lord. I have taken the consent from all the parties.
Part 12, part 2, item number 12.
Yes,
is it?
my Lord.
Okay, Tuesday, noted.
Obliged.
Item 2.
My Lord, pleadings are completed, and if this matter may be listed for hearing, as requested by my senior on 4/8/2025.
Who is the counsel for the, yes, government advocate?
Miss Linda.
So they're saying that pleading is complete in this matter, is it?
Yes, my Lord.
Which is?
It's complete, my Lord.
Miss Ruth
Lilrat Fel.
Lalwat Feli appears on behalf of her senior Mr. L.H. Shima, learned counsel for the petitioners, along with Miss Baby so-and-so, learned counsel for the respondents number
1 to 6.
1 to 6. It is submitted by the learned counsels that pleadings are complete, and therefore this matter can be listed for admission hearing. Accordingly, matter is to be listed for admission hearing after 2 weeks.
My Lord, if date may be fixed on 4/8.
Okay, the matter may be listed for admission hearing as prayed for on 04/08/2025.
Obliged.
Item 3.
My Lord, this matter, I think Your Lordship probably cannot take up this matter because Mr. Malhotra appears for the opposing counsel.
Okay, is his name there in the cause list? Oh, yes.
So perhaps, my Lord, it should be relisted in the other court, my Lord.
List this matter before any other bench except this bench. Then within brackets, my name. Yes.
Obliged, my Lord.
Item 4.
Yes. Service complete?
Lordship, no, upon respondent number one, service has not complete.
Who is
Edit
respondent number one? The main
the
respondent.
main respondent, Lordship, Balaji Developers.
Where's the address? Ghaziabad,
Ghaziabad,
UP.
Lordship.
Then we'll have to wait for some more time.
Lordship,
Or you
let's,
want to issue
Lordship,
fresh notice?
it's second time we've taken step,
Okay.
Lordship, and through through ID card, through register post ID.
We'll wait for some more time. Let's see.
Lordship, 1 week time may be waited.
1 week?
Yes.
Why?
Lordship,
Ghaziabad is
this notice has been
6th.
served on 10/6. It's already 1 month. 1 month has lapsed.
only 1 month. Only 1 month. So we'll list it after about 2 weeks. Let's see what happens, isn't it? Mrs. H. Malswamy, Learned Counsel for the petitioner, is present along with Mr.
David Lalompuya,
David Lalompuya,
For
Learned
respondent
Counsel for
respondent number 2, my lord.
respondent number 2, and Ms. Vanessiame, Learned Government Advocate for respondent number 3. Stop. It is seen that AD card upon respondent number 1 is not returned till date. In view of the above, we may wait for return of AD card from respondent number 1 list after 2 weeks. Are you sure the address is correct?
Lordship, I believe so. Lordship, this is what we have seen in the office website.
Okay. If it's not returned, then maybe the consignment can be traced, but
Yes.
let's wait for 2 weeks first, huh?
Item 5.
Right. Roy.
Yes, counter affidavit filed, not yet.
Not yet, Lordship.
Ms. H. Malso, counsel for the petitioner, is present. Yes, are you filing your counter? Have you filed? While Ms. Caroline K. Lalongoi, Learned Government
Lordship,
Advocate,
we have not yet received
has prayed
instructions.
for further time to file the counter affidavit. In view of the above, list after 3 weeks.
Item 6.
May I please, Your Lordship? Notice is complete.
What is represented?
Not everyone, my lord.
So petitioners to take steps for upon respondent number 4 and 5. AD card returned from
On 13/6, my lord.
let's see the correspondence file. Yes, let's see the correspondence file. AD card returned. Return, here's the return. So it's the deputy commissioner, is it?
My
And
lord.
the SDO,
Yes, my lord.
Khozon, board officials. Not represented today?
4 and 5 has not been are not represented today, my lord.
We'll wait for some time for them to be represented. Meanwhile, find out the government advocate whether they're going to represent them or not. Okay,
My
the deputy commissioner and the SDO, Khozon.
my lord,
Yes,
if I also may make one submission, page number 37 of my petition, my lord. There is one clerical mistake.
why do you make all these clerical mistakes?
Yes, it's a number, my lord.
Where?
So it's page number 37, my lord. Yes, the date dated 2011-2022 should be 2010-2022, my lord. At 9th line from the top, my lord.
So there are quite a few, then below also there's
Yes,
2011.
and third
All
line
of
from the
them,
bottom, yes, my lord.
all of them have to be changed, then you file an
IA, my lord.
I for the making the correction, isn't it? You didn't do your proofreading or one? Before filing your writ petition, because is it in this writ petition or some other writ petition also typographical mistakes were found? And you had prayed
Yes, my
for
lord.
an IA, you submitted an IA for making certain corrections. Anyway, Miss Valentina Laldinpui, learned counsel for the petitioner is present, along with Miss Baby so-and-so, learned counsel for respondents number 1, Ms. Vani Isaiah, learned government advocate for respondent number 2 and 3. State respondents number 2 and 3, and Mr. Samuel L. Sante, learned counsel for respondents number 6 and 7. Full stop. It is seen in the office note dated 13/06/2025 that AD card AD card is received from respondents number 4 and 5 on being duly served. In view of the above, notice is deemed to be complete upon respondent number 4 and 5. However, none appeared for respondents number 4 and 5. Full stop. The learned counsel for the petition submits that she may be allowed to file an IA to make certain corrections at page 37, is it?
My
of
lord.
the writ petition where there is typographical mistake regarding certain dates. Full stop. Praise aloud. List the matter after 2 weeks.
My lord. Much obliged.
That's item 7.
Yes, Your Lordship. This matter is taken up by Miss Mary, and now she is in another court, and if the matters may be passed over.
Okay,
For the
time
time
being
being,
matter.
time being.
Time being.
Item 8.
Lordship,
Condonation.
yes, my lord, this case is handled by Mr. Tira Zekima. He has some personal difficulties today, my lord. So if the matter can be taken up after a week,
Okay, counsel for the applicant is present.
I'm present, my lady.
Okay, since the counsel for the opposite party, have you filed a written objection?
yes,
They
my
have,
lord,
they
we
have.
have,
filed?
we have filed.
Okay, Mr. Lal Ramsanga, learned counsel for the applicant / appellant is present, while mention is made on behalf of Mr. T. Lal Zikima, learned counsel for the opposite party for adjournment of the matter, since the learned counsel is not able to appear due to some personal difficulties. In view of the above, list the matter. And you want a date or list the matter after 2 weeks?
Yes, my lord.
List
I'm
the
I'm
matter
okay with that.
after 2 weeks.
Obliged.
Item 9.
Most obliged.
Your Lordship, I've been requested by Mr. S. Vanderfit, counsel for the applicant, that my lord, her wife underwent surgery yesterday for their newborn, so he could not appear today.
Okay,
And he prayed-
surgery.
Yes, my lord.
He's going to be this thing operated.
No, but her wife will be discharged today from the hospital, so he has to be there. So he asked me to pray for time to release the matter again tomorrow.
Okay, mention is made on behalf of Mr. S. Vanal Shiata,
Yes, my
is
lord.
it? Learned counsel for the
Applicant.
applicant slash petitioner for adjournment of the matter since the learned counsel is not able to appear due to some personal matters. In view of the above, list after 1 week.
No, my lord, if the matter may be taken up tomorrow.
Okay, in
as
view
per
of the
his
above,
request.
list the matter on, we'll make it Thursday. Okay,
madam.
list the matter on, what's Thursday's date? No, not, we will
24th.
list the matter on the 25th, not on Friday. Okay,
madam.
24th, lots of matters have been fixed. On 24/07/2025. Yes.
Yes, madam.
Lordship, in this case, there is a connected in the trial court, which is civil suit number 30 of 2022. And hearing is due, my lord. So if the matter can be taken up after 4 weeks.
You have the counsel for the respondent number.
Respondent number 1.
So what you are saying? There's an appeal, is it?
No, my lord, there is a connected case, which is civil suit number 30 of 2022, in which the RFA came out.
In which?
In which the WPC number 10 of 2022 came out, 2025 came out. So hearing is due this week, my lord.
What is the IA about?
The IA is for, my lord, intervention of the, in the WPC.
I'm not understanding. What connected WPC?
No, my lord.
No, my lord.
This is an RFA. No,
WPC.
Writ petition,
writ
madam.
petition.
No.
But there's an RFA attached here. Some
The RFA is
judgment.
connected to the civil suit, my lord,
Civil suit before which court?
before the senior civil judge. I saw. My lord, we have filed an RFA, but it has been disposed and remanded back to the civil senior civil judge court again, and so hearing is due this week.
So it's been remanded back. Now, what is the connected case you're saying?
That civil suit number 30 of 2022,
Oh,
which is due for hearing, my lord.
so then why have you filed this writ petition?
We have filed this writ petition because the petitioner is the owner of the property covered by LSC number. So
No, but then I think one case in the district court and in this thing, the high court cannot go together.
my lord,
If it's connected, let that be disposed of. Then if it's required, only then a writ petition will be filed, isn't it? Who has filed the writ petition? What is the matter about? I'm not understanding.
My lord, the writ petition is filed for release of the compensation amount to the petitioner in this writ petition.
But it's premature because now you don't know whether you're entitled to the compensation or not because of the civil suit, isn't it?
yes, my lord, that hearing is to be conducted again.
Then first decide on that. Then this writ petition becomes infructuous because you don't know whether you're the one. So there's Vandal Shetty. Okay.
Shetty, yes, my lord.
Yes, Vandal Shetty. Who was a petitioner here?
I am the petitioner.
Then why are you standing there?
My lord, this is in the IA we are for the applicant.
Okay, in the IA. So we can dispose of the IA. What is the IA for?
For intervention in this writ petition, my lord.
No, this Lalshiati, she claims to be owner of a certain landed property,
Yes, my
isn't
lord.
it?
Yes, my lord.
But now they are challenging your ownership.
My lord, there is an award in favor of the petitioner for compensation. So the senior civil judge has stayed for that for the compensation to be disbursed to the petitioner. So they are
Oh,
challenging.
so this writ petition, unless the matter is settled in the district court, how can you file a writ petition for this thing for the release of the compensation to you when it's not even decided whether you are entitled, isn't it?
So, No, my lord, in order dated 3/12/2024, passing civil suit number 30 of 2020 was dismissed as barred by law of limitation. However, the respondent herein, the IA applicant, has sent a letter to the DC stating that this is my land, so don't let the amount not be disbursed. And in that case, the applicant herein had filed RFA 5 of 2025, and that RFA had been remanded back to the civil judge senior division 1 to have a point of grounds of limitation, to have a new hearing. So that is to be conducted, my lord.
You see, the High Court cannot wait for the decision of a lower court
Yes, my lord.
because you still don't have a case here. It appears from what you're saying. Let it be decided in the lower court as to who is entitled to receive the compensation if there's a dispute regarding the facts, I think.
My lord, in that case, if
So the writ petition
the-
at this stage is in,
if the matter
you
can be
withdraw and then to file a fresh so advice after the matter is settled.
my lord, in
in
that
the
case, if
district
the matter
court.
can be taken up tomorrow so that my senior can appear, my lord. I have to take instructions from my senior as well, my lord.
Okay, we'll list it tomorrow.
Yes, my lord.
You see, the IA, leave the IA, the main writ petition itself, when there's a dispute as to who is entitled to who is the owner, what is this thing about? So you withdraw the instant writ petition, and they will hear the matter tomorrow. Let's see what
Yes,
is it
madam.
all about. Because saying that we wait for the decision of the district court concerning this, then why don't you come to this court? Because whatever the decision of the district court, they can always file an appeal again. Then this writ petition, we have to keep it pending till something is decided. So this, at this present stage, it appears, because I'm not very sure of the facts.
Yes, my lord.
I'm just gathering the facts from what is submitted by you. Okay, both of you. Yes. Anyway, on the prayer made by the learned counsels for both the parties, this is matter, tomorrow's date.
Right.
Item 11.
My lord, we are yet to receive AD card from respondent 1 and 6. So my lord, let this matter come up after 2 weeks.
Okay. Yes, Mr. Joseph Lalsan Himarently, learned counsel for the applicant/appellant, submits that AD card from respondents number
1 and 6.
1 to 6 is
1
still
and 6, my lord.
1 and 6 is still await. Mrs. Caroline K. Lilunghoipui, learned government advocate for respondents number
2 to 5.
2 to 5 is present. In view of the above, lists the matter after 2 weeks.
Obliged, my lord.
Item 7, bail application.
Yes. Still on legs?
Yes, my lord.
What do we do? This is the last item. Do you have any hearing matter? We'll go to part 2, then after that.
To item 1.
May it please your lordship. My lord, this is a very simple matter. It has dragged on for quite a bit unnecessarily, in my opinion. The brief facts of the case, my lord, is that I am the owner of landed property located at Zemabo, and it is covered by LSC number SZL 3069 of 1987. So I have been occupying the said property since 1990. I have used it for the purpose of farming as a farm, and I've been in continuous occupation of the said plot of land till date. So, my lord, during that time, the respondent had filed a title suit number 38 of 2015 for for confirming that he is the owner of the property covered under LSA number AZL 3069
Same
of
listing, is it?
1987. No, my lord, this is 3069 is the property of the respondent.
Yours
My
is?
mistake. My mistake, my lord.
Yours is?
Just 1 second, my lord.
You're the owner of LSC CAD number 1853
My lord,
of 2014.
2014.
Now the respondent is the owner
Of 3069 of 1987.
3069
69.
of which year?
1987.
1987.
Madam.
So you're saying that this landed property and yours is within the same,
My lord, it
covers
is
the same,
not covers the same.
land.
It's a whole lot smaller. The property of the respondent is very small, a lot smaller.
it's smaller. So what is the area in your land?
The area of my land, the as per the map provided in the paper book, the area of my land is 1,235 square meters.
And the
And the
respondent
area of
is?
the respondents is 395.46 square meters.
Square meters.
My lord.
Okay, then what happened?
So basically, my lord, the title suit initiated by the respondents, it was initiated without my knowledge. It was proceeded without my presence, and it was disposed. And I was aware of this proceedings only after the final judgment and order was pronounced.
Ex parte judgment against you, you're saying,
My lord,
is it?
my
Ex
lord.
parte order was passed?
Ex parte order was passed, it seems.
Oh, okay, when?
211. To 2016. And the final, the impugned judgment and order is dated 28/7/2022. And we came to this honorable court as soon as we were aware of the judgment and order dated 28/7/2022. So, my lord, with regard to that, I would like to draw your lordship's attention to the lower court records, my lord. There on the order dated 19/17/2016.
Page?
It's not in the
Okay,
paper book, my lord.
in the
It's in the lower court record.
records. Two thousand
16, 19/7/2016. The second page, my lord. On the next page. there issue summons to the defendant number 5, Bantroma, son of Rosie, resident of Dorpuiveng Aizol, to be served by the plaintiff. Now, direction was clearly given here also. And however, no steps were taken, and I was not made aware. No summons was given to me. I was not aware of the,
To be served by the plaintiff.
my lord.
Okay, so anything to show?
No, they have nothing to
What
show.
is the next order?
Uh,
Was it served or not?
There's nothing to show that in the order sheet, madam. We were totally unaware of the proceedings
You are
of this court.
defendant number
I'm the defendant number 5.
5. Okay, now in the other following orders. Again, 22/8/2016. Defendant number 5 is absent. Issue notice to defendant number 5. This sort of things. So after that, on 22/08/2016,
My lord.
issue notice to defendant number 5. There's that order. So notice must have been issued.
However, we were not aware, my lord, because we have been in continuous occupation of this property since 1990. And we have not just been occupying, we have been actively involved in the occupation of this land. We have been using this land for farming. And not once has the respondent even told me that this is my land.
So here, then there's another order. You have led this court to only one order, isn't it? Then there's 22/8/2016, issue notice to defendant number 5. Then this is order of the court on 07/10/2016,
My lord.
which says give a copy of this order to all concerned. That is fixed to 11/2016 for submission of WS by defendant number 5. Anyway, it is for the respondents to show us
My lord.
with the notice. So you are basing on the order dated 19/7/2016, saying that notice was not given. But what about the subsequent orders of this court?
And on
That copy
2/11
should be given, you should be informed.
On 2/11, the ex parte order was passed, my lord.
2017.
My lord.
Two 11, let me see. Issues were framed. Parties are present through the councils. So when they say parties are present, it is without you being present, is it?
I don't know about the rest, but we were not, my lord. because we were not
211,
aware. My
ex
lord.
parte, when was your ex parte order passed?
2/11, my lord.
2/11/2017,
2016, my lord.
2016. Here, on perusal of the case record,
My lord.
defendant number 5 was in due receipt of the notice
That-
issued through court. However, has failed to give appearance till date.
my lord.
So,
We have no knowledge of that, my lord, because no notice or summons was ever issued to us, was given to us. We were totally unaware of the proceedings.
what about this order?
I have no knowledge about that, my lord.
Anyways, we'll have to see whether
Anyway, my
notice
lord,
was received.
yes.
Huh?
And with regard to the ex parte order, my lord, my learned friend had raised the contention that the ex parte order has to be set aside first. So, with regard to that, we had already had a hearing before Justice Michael in this matter, and according to the advice of the court, I was advised to file a amendment that has been filed as IA Civil Number 175 of 2024. And in that, an order has been passed wherein it was stated
Let's see
that
the IA.
in the IA, an application was made to add, to challenge the ex parte order dated 2/11/2016.
211, yes. Then,
And in this regard, an order was passed dated 23/10/2024 by Justice Devashish Bawla.
where's the copy of the order?
Uh,
In the IA or in the main?
IA, in the IA.
Yes, 23/10/2024, is
My
it?
lord, my lord.
Yes.
And there at paragraph number 3, this court taking into account the provisions of order XLR Rule 1 read with Appendix G and Section 1.5 of the Court is of the opinion that such amendment is not required as per provision of law. The order dated 2/11/2016 by which the suit proceedings have been proceeded ex parte is within the scope of the appeal in view of Section 105 of the Code. So with this order, the IA was closed.
What does the order say? Order 41, Rule 1. Give me the background. That such amendment is not required. So the order dated, this order 02/11/2016, by which the suit have proceeded ex parte, is within the scope of the appeal in view of Section 105.
The
of
basic
Code.
understanding of the
No, give me the CPC. Let's see.
the basic understanding is, Your Lordship, that the ex parte order does not need to be challenged separately.
Okay, so you're challenging this in the 105 of the CPC.
No, my lord, appeal has already been filed, and the contention of of my learned friends was that the ex parte order has to also to be set aside, separately. So we had, as per the advice of this honorable court, I had made an application for adding.
That's what we're looking at, the order of this court,
My lord.
105.
My lord,
So order dated by which the suit proceeded is within the scope of an appeal in view of 105 of the code. So what's 105? You have heard the matter, so tell me. No appeal shall die from any order made by a court in excess of order, but when a degree is appealed. Okay, so now you have filed an appeal against the degree of the court. So now you have filed an appeal in the RFA, is it?
my lord,
Against the degree
My
of the
lord.
court, where it includes the irregularity of the order, that is 02/11/2016.
my lord.
Is it so a separate appeal It's not required because an RFA has been filed.
It covers
is
the entire thing.
Ah,
RFA
okay.
covers the-
So we'll have to look into this order 02/11/2016, where you said that this order is wrong because this court had observed that you have received a copy of the sermons have been received, isn't it? I think that's the main thing in this case.
That is the only thing, my lord. We have come
Against
because
the
we
ex
are,
parte.
my,
So your prayer in the appeal is that you should be given a chance
my lord.
to file your WS and challenge the contest the claim, is it?
My lord.
Okay, so any judgments to rely on?
No, not particularly. We had the hearing before this honorable court previously, and I had
Before which court? Which bench?
pardon, my lord.
Which
Before
bench?
Justice Michael, ma'am.
Then?
And Justice Michael gave the advice that I should amend the plaintiff to include the to challenge the order dated to.
So you have
So I've done
included,
that.
so any authorities to rely on?
Since that particular point has been cleared up, my lord, so I have not brought.
On
yeah,
this particular point, any authorities? No.
No, my lord.
Your simple submission is that this order 02/11/2016 is wrong.
My lord.
Because you did not this thing. Okay, so it's for the respondents to prove that it's not wrong. It's as simple as that. Yes. An order made by the court, huh?
Yes. My lord, my very short case, I just want to brief that is that, my lord, I had my LAC in the year 1987. If you kindly see my LAC, I would like to take you to the copy of my LAC, lordship.
See, we are not looking into the merits of the
My lord,
case.
that's just one, before I proceed my submission, just 2-3 sentences.
You have a LSC before the appellant, huh?
Yes, lordship. So my 1987, so their LAC is 2014. So that's point I would like to stress one before I proceed further. So the law is well settled. I'll submit citation, a judgment passed by this coordinate bench also. Even that case also reported, and that was also challenged in SLP.
No. That merit we are not going to see. We are going to. He only wants challenging the order 02/11/2016.
My lord, as he
We are not
fairly
looking into the
submitted,
merits of
it's
the
true.
case.
As he fairly submitted, we had a hearing before Justice Michael. That time, he has not challenged that order 211.
So because of the IA that it can be challenged now, so see,
My lord,
today,
yes.
the RFA is regarding the ex parte order, which is praying for setting up of the ex parte order by stating that because of the ex parte order, he was not given a chance to file
Yes, my
his
lord,
WS and
I got the
challenge.
point.
So
My
only
lord.
that.
Yeah, I got the point. My lord, there are two conflicting view by that the judge who already heard. One judge say you need to challenge, you have to make amendment. One judge say it is reflected as he fairly admitted
Yes,
also.
so-
And the next judge say that you don't need to challenge. So in that
Where? Who says?
no, the first judge, Justice Michael, say that you have to challenge, you have to amend your petition. And he amend the pen, he file amendment.
Yes.
And the next judge say
Which next judge?
that order Barwa, Devanshi Barwa.
Where?
You just have read, you just have read. You have just read. That
Where's the order?
in the IA itself.
In the IA?
Yes.
The IA is passed by.
Just now we have read.
Okay.
Order 2311.
Listen, you don't mention Justice Michael's name because he has not passed any order. Okay?
Yes.
So the only order which we can consider now is the order passed by Justice Barwa.
Yes.
Don't say the first judge because where's the order of the first judge? Is there any order
But
passed
actually
by
there-
Justice verbally?
No, it is there.
Where?
But
Where is it there? Where?
okay.
Show it to me. Ah.
Your Lordship, at 23.
In the IA?
No, in the main case. In the main case.
In the main case. Okay, let's see in the main case. Ultimately, what happens is the the order dated 02/11/2016 has to be looked into. That's
Yes.
all.
Yes, exactly.
So,
12/9/2024. 12/9/2024.
lead me to all the case. Show me what is going on. 12.
9/2024 in the main case.
Yes, okay.
Mr. Valanga Kalanet counsels for the appellant submits that he would like to file an application for amending the prior portions of the appeal for setting aside ex parte order.
So,
So he fairly admitted that.
yes. So what's wrong?
So-
he's filed an amendment. Has he
Yes.
filed?
Yes, he's filed.
Yes.
So, my lord,
So there's nothing conflicting.
Yes,
There's
my
nothing
lord.
conflicting.
That this at this juncture, what I would like submit is that if you kindly see ex parte order,
The ex parte
so
order.
because
Only
the-
that we're
it is
going to look.
what I said, it is barred by law. It is barred by limitation. What I would like to search. If you kindly see Article 123, if you kindly see 123 of Limitation Act,
Okay, give me the limitation.
that time also the judge orally observed in the court that, oh, you have to make continuation of delay, but it was not reflected in the order. But this is the law. Article 123.
Yes, how many years?
30 days from the date of the decree or when the summons or notice was not duly served, when the applicant has the knowledge of the decree. There is no years or days, but from the date of knowledge of the decree. So if you kindly see the application, so
From the date of knowledge of
yeah, from the date of
decree.
knowledge, if you see, kindly go to the application, you'll see when he came to
Application
know
of who, where, page what?
their memo of appeal,
In the memo of
Yes.
appeal, okay, page
144.
You're saying it's barred by limitation.
Yes.
144.
$145 is the relevant.
142 is what? This
It starts from
this is the
140.
RFA file.
Yes, RFA.
So the RFA was filed on when? 144, 145.
145. Here we can say that when he came to know about this judgment, so he came to know in the month of August 2022.
Okay. Judgment in August
Yes. So my strong point is here is
2022. Okay.
Because-
And then when is the RFA filed?
RFF was filed on 27 October 2022.
August, September,
Yes.
October.
My point is that there is no continuations of application, delay application, because law is very clear. I can rely the judgment of this court
30
also.
days. It says 30 days.
Yes.
This will be how many days? More than 30 days?
Yes,
August. In the month of August, simply August, date is not mentioned.
not at all.
So supposing it is on the 30th August, presuming 30th August, then 30th August, even if it's on the last date of August, it's still 1 month, September. It should be in the month of last week of September or the first week of October. So it's 27th. So a few days, is it?
Yes, but my point is that there is no application for continuations of delay. And there is no specific challenge to that ex parte order also. It was
In the amended?
in the application itself. if you kindly see page number 143,
In 143, there will be nothing.
no,
That's
if
why he was
the
allowed
prayer
to
is there,
make- Yes.
an appeal under such and such, 96, read with such and such, ex parte order, through 11. Actually, for setting aside ex parte order is order 9 rule 13 against 2/11/2016. Here it is mentioned, but there is no prayer at the last prayer portion.
Prayer will be
Prayer
page-
portion is 148. Here, if you kindly see the prayer A, admit this appeal, issue notice to the respondent to call for record. After hearing the parties, the court may kindly please to set aside and quash the impugned judgment order dated 28/7/2022. Here, there is no prayer for setting aside of that ex parte order. This is my point.
Okay.
Yes, there is no prayer, and how can they get relief? And there is no condonation of delay application also.
Okay.
So that is one of my point. And second point is that, Your Lordship,
Please go ahead.
even if their contention is admitted as a gospel truth, whatever they say, because they obtained LAC in the year 2014 only, and we already had LAC in the year 1987 in my name. If you kindly see my copy of LAC, I would like to take you to my copy of LAC, Lordship. Page number 10. Page number 10. Page number 10. Annexure A.
Yes.
Certificate of LAC number LZL 309 of 1987. Name of owner Saingura Silo. Kanan. Yes. So if you see again their LAC,
Yes.
page
go
number 79. Page number 79. Their LAC is 1853 of 2014.
Yes.
So, my lord, the law is very clear. It is in 2018 AR volume 4 GLT 749 that we downloaded from the internet.
Name of the case, Zampui versus
Zampui.
State of, okay.
Yes. GLT
This is Supreme Court proceedings, the apex court.
No, the next one, this case was preferred challenge in Supreme Court and Supreme Court dismissed.
Okay, so.
I have given to you also that dismissal order also.
So, okay, the RFA 10 of 2014, is it?
Yes. I would like to read from it, relevant from 17 also,
Para.
para 17. The issue in question lies in a very narrow compass, whether allotment of House Pass 1959/1987 and subsequent LAC 2000-294/1990 was validly issued. It is an admitted fact that the land belonging to respondent number 5 is covered by House Pass number 9854 of 1974 and LAC number 312/1985, which is prior in the time to the allotment of the land to the appellant by way of House Pass 539/1989 and LAC 394/1994. At the times of issuance of House Passes and LAC in question, Section 4(6) of Mizo Land and Revenue Act 1950 were applicable. Section 4 and 8, no person shall acquired by length of possessions or otherwise any right over land disposed of, allotted or occupied before the commencement of this act, unless such land had been recorded and registered either in DC office or district council office. Power of administrator over vacant land. In case of land, any land cover which no person has right of use or occupancy under this act or which is not under use of occupancy of the government, the administrator may direct that such land may be disposed of by way of grant, lease, or other ways in many manners. The person who has entered unauthorized occupations of such land may be rejected in the manner prescribed. Any crop building or otherwise construction erected without authority may be disposed of in the manner it deems fit. A perusal of the above two provisions would go to show that allotment of land can only be done in respect of vacant land. Accordingly, appellant land covered by House Pass 1989, subsequent LSC 394, 1994 cover land which already been allotted by way of House Pass 854, 1974.
So reach para this thing 18.
Para?
18.
A perusal of the two provisions would go to show allotment of the land can only be done in respect of vacant land. Accordingly, as appellant land covered by House Pass number 539, 89 and subsequent LSC cover land which had already been allotted by way of House Pass number 854 or LSC number 312, 1985 and which were not cancelled by the authorities. The allotment of that portions of the appellant land which encroach upon the land of the respondent number 5 is not valid. To that extent, appellant house pass and LSC would not be valid.
So leave it at that, isn't it? Huh?
Yeah.
So, yes.
Because my point here is that
The only thing is, when the appellant
yes,
filed the amended RFA, is it the one which you just read now?
yes,
The amendment?
yes.
Okay.
And my lord, in this case, the respondent LSC was junior. So, and the respondent was senior, appellant LSC was junior. So, they claim that he was not occupied. And then they issue LSC. And I had been looking after. In my case also, here the respondent, he's a judge, sitting judge. He did not have time to go all the time to the place. He did not go. He admittedly, he did not have any construction. But his land was much, much senior. So it can be seen from the evidence also. My lord, this is very clear in this case also, and it is applicable. And my lord, I have also furnished the judgment passed by this court. It's another one, small, short one. Size,
Yes, Saiziki Silo.
yes. If you see from very short one, where exactly applicable in my case. The appellant before us instituted civil suit number 1, 2099 before additional district magistrate, stating in the land measuring 0.32 bighas situated as Narivang, Bungkon, Aizol herein referred to the suit land, was settled in the plaintiff name in the year 1977, and the land settlement certificate was issued by the competent authority. The land was demarcated and the plaintiff was paying annual tax. He had also obtained housing loan mortgage of the suit land in the 1992. Respondent number 5 occupied the suit land and constructed a sum-type building. The appellant petitioner therein prayed for declarations of his right and title for evictions of the respondent number 5 from the said land. The suit was decreed by the trial court for possessions and compensation to be paid by the state. Thereafter, respondent number 5, government preferred an appeal RFA 12 before DC, and the said appeal was disposed of on 14/1/2002, whereby the decree for eviction was set aside. But the state appellant was directed to pay compensation to the respondent. The appeal is before us. So far, the facts as stated are concerned. There is no dispute at the bar that the suit land was settled in favor of the plaintiff in 1977. However, the plaintiff did not make any use of the land, and the land was vacant, whereupon the concerned authority issued a house pass, and thereafter, on the basis of the house pass, the defendant, respondent number 5, occupied the suit land, constructed the house. It may be mentioned that in the meantime, the respondent number 5, Rothang Leni, died, and his son Moses has been impleaded as substitute service. Substitute respondent number 5. From the materials on record, we find that the respondent made 2 allotments over the same land, one in favor of the appellant, subsequently in favor of respondent number 5 in the year 1990. It is submitted that the suit land was found vacant when subsequent land settlement was made. The learned counsel for the appellant, on the other hand, submits that there is no requirement of law that after settlements of land, construction is to be made within particular period. After getting settlement, it became heritable under Section 12 of the Mizo District Law and Revenue Act 1956. Admittedly, the settlement in favor of the plaintiff has not been quashed or cancelled till now. We therefore find that appellate court below failed to appreciate the law in proper perspective and taking a compassionate view. In the matter, allowed the respondent number 5 to continue with her position. The finding of appellate court cannot be maintained. Appeal is allowed and it is provided that the suit be decreed for declaration of the right title in favor of the appellant and recovery of his position. Respondent number 5 shall hand over the vacant positions of land to the plaintiff within a period of 6 months. So far as the relief compensation is concerned, no compensation is to be payable by the state to the plaintiff. So far, respondent number 5 is concerned, he will be at a liberty to seek necessary relief, if any, before proper forum. This is exactly same with my case. This also, the government allowed.
Okay, now is it, now it is not disputed in this case that both the LSCs are within the same landed area, is it?
Yes,
No,
yes,
my lord.
because they clearly stated in
Within
memo
the
of,
same landed area? But here he says that one property is much larger than the other, the area.
my lord,
One
this-
is 1,235 square meters. The other is only 395 square meters.
yes, my lord,
So you're claiming the area which is covered by 395, not the rest, is
yes,
it?
yes. My lord,
Simple as
here,
that, huh?
I would like to make the query because this property was purchased from the same owner. It is in evidence also, and from the same
No, but
VC pass.
you're claiming ownership over the landed property which is covered by 395
Yes.
square meters, not more than that.
My lord, if you kindly see the evidence also, even or the detailment order, it was proof at the court also. Allow me just to go through it very short.
No, leave it at that. No, just this clarification that even if the LSC of the appellant
Yes,
is 1,235 square meters, you're claiming only the area covered by your LSC, which is 395
I
square
cannot claim
meters.
more than my land.
Okay, so it's clear as that.
Yes, it's clear. The law is very
Leave it
short
down.
also.
So if there's any extra land beyond your landed property,
If
then
extra land is there,
belongs
that
to
it
the
belong to them.
appellant.
You can direct the
Okay.
revenue department
Yes.
also.
No need. Why should I direct?
Yes, my lord, if you lost
That
it.
is not a part of the
Yes.
play. Yes, so, yes, heard. Where are my PSs?
Your
Anything
Lordship,
in rebuttal? Yes.
With regard to the the plot of land being covered, the two same plots of land being the same, we have an opinion that they are not the same, because my lord, a simple perusal of from page number 18 of the paper book, the maps of my land and the maps of the land of the respondent, my lord, it can even be fathomed from that simple look at the maps that they are not the same plot of land. my lord.
If they are not the same plot of land, then you don't have any ground to file an appeal. You have a different plot of land.
My lord, they admitted.
That is what we think, but we have not had any chance to say that.
No, no. See, the trial court has given them ownership over a plot of land covered by their LSC.
My lord.
Now you're saying that my LSC doesn't cover that plot of land, then you don't have a case.
No, my
only.
lord.
You have your land somewhere else.
The plot of land that I have is there, but the plot of land claimed by the respondent through his LSC, the truth is that they do not know where their land was.
My lord, they admitted in para 2 itself
My
very
lord,
clearly.
if I may take your lordship to page number
Anyways,
81.
that is looking into
Just-
the merits of the case,
My lord, that is true.
which requires evidence
My lord,
to
we
be
have not-
recorded.
We have not had the chance. my lord.
Where he says, so it's basically, this case is basically to decide regarding the ex parte order. Because if we then consider your submissions when there's already an ex parte order, then your evidence is not there on record. Then we cannot consider, isn't
My
it?
lord, here they say that in para 2, very clearly that this is, they admitted that the land, appellant is owner of the LLC, which was converted from VC Pass, bought from the appellant from Ringheta in their 1990. It is very clearly that it is at evidence by the state witness also.
State.
Yeah, by the state witness.
Now we are concerning the evidence of the appellant. He's claiming something else. So we'll see. I think the only issue to be considered by the appellate court at this stage is whether to set aside the ex parte order or not, and whether to give chance to the appellant to file their WS, and matter should be this thing considered afresh with giving a chance to this. So that is the issue to be considered here in this court. Okay. So
Yeah,
we'll
but
make
to
it
challenge them that impugn that order 2/11/2016.
You've mentioned
My
that,
point is that, yeah, it was barred by limitation, no condition
Yes,
of.
yes, I've heard.
Yes,
You have made your submissions. Heard Mr. So-and-so, Learned Counsel, Vanlal Khaka, Learned Counsel for the appellant. Also heard Mr. J.C. Lalnunsanga, Learned Counsel for respondent number, private respondent number 1.
Yes, Lordship.
I think in the last court date, the government has said that they have
Yeah, they
nothing
are
to
not
say. It is
contesting.
also submitted by the learned government advocate that the state respondents are only pro forma respondents and have no say in the instant matter. In view of the above submission, hearing is concluded. Matter reserved for judgment. Yes. There's one time being matter.
One time. Item 7.
Yes.
Lordship, learned PP is still on legs, and if the matter can be taken up tomorrow.
Okay, on the prayer made by the learned counsel for the applicant / petitioner, this is matter tomorrow's date.
Yes.